Hello, this is Matt on the Moon Lambo channel. The SEC has no shame. The SEC also doesn't know what ethics are. So there's a few deficiencies right there. Take a look at this headline though. My gosh. This comes from A to ZMarkets.com. SEC threatens court with far-reaching consequences if they lose Ripple lawsuits. There you go. Now they're whining, and specifically to the court, and saying, hey, judges, just so you know, I mean, if the wrong conclusion is made here, I mean, this is going to have broader implications than what you might be thinking, so be very careful, which it sounds kind of like an intimidation tactic towards the court. But again, of course, they have no shame. They don't know what ethics are. They functionally do not care. How many? Well, I'll have to censor myself. How many damns do they give? They give zero damns. They give zero damns. I wanted to use the more abrasive term that starts with the letter F. But there could be some children's in the background. I don't use any strong vulgarity on this particular channel. I'm just saying here. But take a look at this. I don't want to run through this whole piece, though, but you can kind of get the gist of it. I will cite this part, though. SEC intimidates the court with consequences in the event of a loss. The exchange regulator believes that the loss, well, assuming it happens, will harm the SEC far beyond the scope of this case. And, you know, frankly, the SEC should be concerned because they're running this case like a bunch of belligerent children that don't know what the hell it is that they're doing. In fact, I'm wondering if they're drunk half the time they're doing their law stuff. I don't even know, man. And so I wanted to share with you something from attorney John Deaton. He shared some, because basically it's just, look at what, because look at the headline, look at what they're citing here. And then consider what even got us to this point, because John Deaton kind of takes us through it. And so I wanted to share it with you. And so this article was shared pretty widely within the XRP community, at least on Twitter, by MacAttack XRP. And attorney John Deaton saw that. And so I'm sure many of you are familiar at this point, probably the vast majority of you. But John Deaton, in case you're unaware, he's an attorney within the XRP community who is seeking to intervene in the SEC versus Ripple case on the behalf of 17,000 plus XRP holders, because frankly, our interest as XRP holders not being sufficiently acknowledged in the case if we're not even there. Because, well, clearly the SEC views us as problematic, so they're not looking out for us, and then it's not Ripple's responsibility either. And then with how broad and open the XRP ecosystem is, there's no way that they could sufficiently cover the interests of everyone else that's not them, nor should it be their responsibility. They can't and they shouldn't have to, frankly. So anyway, John Deaton saw that tweet from MacAttack XRP and wrote the following, which I want to share with you. A partial historical review of SEC versus Ripple. The SEC waited 8 years to bring a case against Ripple, allowing individual investors to buy XRP on over 200 exchanges worldwide. In 2015, the Department of Justice and FinCEN declare XRP a convertible virtual currency. Yeah, and so I'll pause there. That meant when it was declared that a convertible virtual currency, that was actually a big deal for the entire crypto space, because it meant that XRP was being regulated just like you're regulating money. Not like you'd regulate a stock, of course, a security, but like you'd regulate money. That's a big deal. It was actually a bit of a step forward, frankly. Anyway, John Deaton continues. In 2017, when the SEC aggressively sued companies in the digital asset space violating securities laws, it left Ripple and XRP alone. In 2018, the SEC allowed Ripple to purchase a 9% stake in MoneyGram, fully knowing XRP would be transferred to MoneyGram, who would in turn immediately sell it in the secondary market on exchanges like Coinbase to individual investors with no connection to or even knowledge of the company Ripple. So pause right there. Think about that. The SEC approved of that relationship, knowing XRP absolutely would be a part of it. They had no issue with it whatsoever, but if they really believe that investors have been harmed by XRP being sold by Ripple as a security, why would they allow it to happen more? Why would they make sure that more XRP gets out into the wild and it's transacted further? Why would they do that? Well, because even they at the time weren't convinced that XRP should be considered a security. That's the real answer. but they're not going to acknowledge it now. Now they're pretending like they've provided fair notice despite the fact that they've helped facilitate this. And don't forget that also the SEC paid a third party to run an XRP validator so that they could learn how it operated, which means they were utilizing United States taxpayer money. They were using that to run an XRP, have a third party run an XRP validator, which facilitated those activities that the SEC says were being illegally transacted. The SEC was helping that. I know it sounds completely upside down, but the SEC actually did that. They really did. They were running a validator. Technically, it's a third party, but in my eyes, that's even worse because they're paying a firm with taxpayer funds to do that. And I get it, even if they did it themselves, fine, but you're adding a middleman. And so, who knows? You know, with it being the government, you can only imagine what it would have cost, right? Something outrageous. But anyway, John continues. Where was I? Right here. I think it was right at this spot. Yeah, here we go. After more than a 2-year investigation into Ripple and its executives, the SEC could not find one instance of fraud or misrepresentation. In 2018, Hinman, pause right there. He's referencing William Hinman, a former SEC director. So in 2018, Hinman gratuitously declared Ethereum not a security while collecting over $15 million from his law firm, a member of the Ethereum Alliance. In October 2020, 2 months before Clayton leaves the SEC, One River invests $1 billion into Bitcoin and Ethereum. So that's a hedge fund activity right there. 2 weeks before filing the case, former SEC Commissioner Grunfest warned Clayton not to file because there was no exigency and investors would lose billions. Billions, my friends. Grunfest informed Clayton that the SEC had made no material distinction between Ethereum and XRP, and if he filed the case, it would call into question the SEC's motive and discretion. Now, despite this grave warning, and a new administration coming into power in less than 30 days, Clayton directed a suit against Ripple and XRP on his last full day at the SEC. Less than 3 months later, Clayton accepts a job with One River as an advisor on its Bitcoin and Ethereum investments. Well, how about that? For the first time in history, and directly against precedent such as the Telegram case, the SEC claims the digital token XRP itself is a security. The lawsuit causes $15 billion in losses to XRP holders. Yeah, and so look, for those of you that saw the price drop down to whatever, I think it got down to like 16 or 17 cents after this terrible, scary news happened with the SEC going after Ripple. For those of you that were able to purchase 16 or 17 cent XRP or very cheap, a lot of you got it in the low 20 cent region I've seen. I am happy for you to have that opportunity, but still, this shouldn't have happened. Nobody should have had that opportunity, frankly. And billions of dollars in loss. My gosh, there are people that lost fortunes, and it's disgusting. And so again, I'm happy for people that took the risk and seized the opportunity, because if that's what you wanted to do, because XRP, as we know, did end up running up to about $2 recently, despite the fact that it's retraced a bit since then. My gosh. The fact that this happened to these people, and then the SEC, they don't even care that this happened. And they're pretending like it's the fault of exchanges for all of this occurring. It's disgusting. Anyway, John continues, despite claiming that the executives at Ripple enriched themselves selling unregistered securities to the present day, the SEC allows the co-founder, Jed McCaleb, to sell billions of XRP before and after the lawsuit was filed against Ripple. The SEC has yet to produce court-ordered relevant discovery related to Bitcoin, Ethereum, and XRP. Judge Netburn has ruled the discovery is both relevant and necessary, not just related to the fair notice defense, but also for the court's analysis of the Howey factors relevant to XRP. Now, the SEC objects to XRP holders being heard in the lawsuit, even though it claims it brought the lawsuit on behalf of those investors. And look, I gotta say too, this is one of the most rich things about this. Did they think that the XRP holders were going to be thrilled? Because normally when there's an action brought, whoever they're bringing the action on behalf of, they're usually happy. You know, they're usually pretty thrilled about this. And then you have this massive backlash, which does not look good in the eyes of the court. There's no way it could. With John Deaton seeking to represent over 17,000 XRP holders who voluntarily signed up to be represented, you know, should that be allowed within this case, like over 17,000. This is unheard of. This is unprecedented. Like, this is absolutely nothing like this has ever happened before. And it just speaks to the degree to which the SEC is completely out of sync with reality here. And so John continues, instead of addressing the arguments made regarding the independent utility of XRP, the SEC attacked the lawyer representing XRP holders, claiming he is biased and unfair to SEC. After losing several discovery disputes, the SEC warns the court that if it loses the case, it will cause irreparable damage to the SEC related to future enforcement actions in the cryptocurrency space, and the court should consider such consequences before ruling. And so I'll provide commentary there. Like they're the ones that caused this. They're the ones that put themselves in this position, and now they're crying to the court, if anything, trying to intimidate them, saying, hey, look, this is going to have such broad implications. You can't allow this to go down. No, you did this, you little asshats. You did this. And so John wraps up by stating the following. I won't make any editorial comments. Our motion to intervene is pending. For the record, all I've done here is provide a true and accurate review of some of the factual history thus far. I'm not being biased or unfair. History speaks for itself, and you can make your own conclusions. Yes, absolutely. So don't worry. I understand why John Deaton didn't provide additional editorial comments, but Moon Lambo is right there. And they did it. They did it to themselves. My gosh. And now they're crying like a bunch of little bitches. I don't know what else to say, guys. Like, can you imagine, like, the audacity of these people? Like, they just don't care. They must feel so utterly invincible because they're part of the United States federal government that they just don't care. And they really don't have any shame. And they have no ethics whatsoever. And it's just, that's why, to me, it looks like a money grab and a power grab. That's exactly what it looks like to me. Fund their operations by unethically trying to force money out of Ripple. That's effectively what it looks like to me, and showing no concern for the harm that was done to investors. In fact, the first time I saw any sort of acknowledgement of the harm that was done to investors outside of, obviously John Deaton and other members of the XP community, it came from Ripple. Ripple was the one that first publicly acknowledges. But the SEC, no, they didn't even broach the subject until there was a claim against them having caused this, and then even then they refused responsibility and claimed that it was the cryptocurrency exchanges delisting that caused this. And I'm like, I'm sorry, what was one step before that? I'm sorry, the exchanges? You're the ones that aren't providing clarity for XRP. If you think that XRP is a security, then yeah, all this makes sense. If you don't think XRP, by the nature of existing, is a security, then why wouldn't you provide the clarity necessary? Because you knew this was going to happen. That's just so disingenuous. It's disgusting and completely repulsive. So I want this whole thing just to be done. I want it to be settled or whatever, and just move on. What a train wreck, though. Either way, my gosh, the SEC did that. They absolutely did this to themselves, as far as I'm concerned. And then there was this from another attorney, Arturo Portilla, who read John's thread, and he shared the following in response to what John Deaton wrote. Yet the whole United States crypto industry chooses to act as if the case was only relevant to defendants, meaning Ripple, of course. The SEC itself is now acknowledging how an unfavorable verdict could harm their oversight across the industry. What else do we need to understand the relevance of the case? Yeah, exactly. And so that's relevant because there are all sorts of other participants within the world of crypto and blockchain in the United States that don't recognize that this will impact them. So depending on how this goes, SEC could just be coming for you next. This is not just a Ripple problem. This is a cryptocurrency problem. If this doesn't go well for XRP, it's not going to go well for anyone else in all likelihood. But I will go ahead and wrap up there. I'm not a financial advisor. Do not buy or sell anything because of anything I say or write. That would be a very, very, very bad idea. Until next time, To the moon, Lambo.